We're live. Thank you, Angela. All right, well, this is Thursday, April 29th. This is the second policy committee meeting of the month. We have 17 J policies to finish up, and some of these are my favorite. They're like from 1981, so I'm so excited that we're reviewing some of the oldest on the books. So we're going to put a new date on them at least today.
Yay!
Yay. So let's see, I guess I should call the meeting to order. And did anyone check out the minutes from our last meeting and double check to make sure they were okay? Any comments or concerns about the minutes? Okay, shall we approve them then?
So moved.
Second.
Okay, all in favor? Aye.
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 Okay, great. It's unanimous. All right, so next comes the superintendent's report. Dr. Thomas, did you have any words for us today?
Dr. Yeager?
Yes.
Sorry, you skipped the amender. Not sorry, the amended off the agenda.
You're right. God. Sorry. Shall we amend or adopt the agenda? Lawrence, are we okay with these policies today?
Well, that's the only reason I recalled it is because we do have a request to pull a JGF off, so that way Dr. Watley and Ms. Jolliffe have more time to, they're actually rewriting the policy completely. So they're doing a lot of great work on that. So they just need a little bit more time on it.
Okay, that sounds good. Yeah, because I was going to comment that it needs a little bit more organization. So that sounds great. There is a lot of good content in there, but it's just really hard to get into it. So yeah, that's okay. That's fine. So we will pull number 7.
We will be ready next time. We're rounding a curve on that one.
Right.
Take your time. That's a difficult policy.
Yeah,
It is very difficult. Yes. Thank you, Nicole.
No problem.
Okay, so any other amendments or changes to the agenda? Everything else is good?
No, that was the only request we had.
That's the only one. Okay. So we take a motion to adopt the agenda as amended, removing number 7.
So moved.
Second.
All in favor?
Aye.
Okay, now, Dr. Thomas, the floor is yours. Pardon me.
No problem. Thank you. Good afternoon. I think it's still afternoon, everyone. Hope you had a great day. I do not have anything. I've spoken to Dr. Watley briefly today, and I know that there are a lot of policies for us to get through. And so I just look forward to contributing as appropriate.
Okay, thank you. Nor do I have a report today. I think we are coming close to the end of the J policies. After we finish this meeting, I'm going to go back through and do the big check, double sort. Angela, you can expect a few emails from me if I find loose ends, but my plan is I think we've gotten through everything after this, and then we might just have some loose ends, and then bringing forth, of course, the things that we have put off over the last few months to push to after we get through J's. So that's all I have for my report. Shall we dive right in? Mr. Pruitt, I did want to ask you, I noticed there were no attorney memos on many of these. We will just invite you to comment as we go through.
That's fine.
Great, thank you so much. Okay, so the first one is JCDAF, last reviewed in 2012. This one is a review only, and it's about electronic devices, mostly that we're not responsible for the devices that children bring to school, and they are responsible for the devices that we give them. So I guess it's review only. Any comments or concerns?
I do. I have.
Yes, please.
So are we issuing devices in lieu of textbooks? Because my concern would be if we're requiring students to access text material through CCSD issued devices, how can we enforce that? You know, how are we gonna, I guess, how are we gonna make parents responsible for the devices if we're forcing them to use, if we're forcing them to use the devices? And I don't know if we are.
That's a good question. I know my students, my sons have received textbooks, but I don't think it's in lieu of a device. It's just in addition to a device. So my understanding is every child gets issued a device, one way or the other, whether they're using it actively or not. I know that there is an insurance. Maybe we need to mention that in this policy, is that there is insurance that parents can buy. It's not very expensive for those devices. Mr. Pruitt, would it be prudent to mention that option?
Well, you know, I'm always trying to make them as general and long lasting as possible. You don't know how that might change in the future. You know, I mean, I don't think this is anything different than we say about textbooks themselves.
That's what I was about to say, Attorney Pruitt. We say the same thing about textbooks. If they're damaged, I don't know where it is in the policy, but damage or intentional destruction of textbooks, I know that, you know, they're required to turn those in at the end of the year, and there's like some soft effort to ensure that those are returned and not damaged. I helped with collection during actually last year at one of the schools. And, you know, the students brought those in, they were scanned back in, so they're checked out. So there is kind of that same policy with any district materials.
So
I'll let it, I'm sorry, go ahead, Dr. Watley.
no, you're fine. Do we need to add a statement here, Mike, about insurance, or should we just kind of leave it as is?
Well, I'm thinking just leave it as is because,
Okay.
you know, you don't know how that might change in the future.
Okay.
So I'll leave it alone. I just know that for one of my sons, when he kept the CCSD Chromebook over the summer, when he went to turn it on, it didn't work. And we've had some issues with chargers. And so as a parent, I don't want to be responsible for those. And this policy reads that I would be, and I would be inclined, if it was optional, to even consider not having them issued a device for that reason. And when we talk about the pre-Kers with their iPads, I'll back off of it, but I want us to have some flexibility so that if the students are required to learn via these devices, that we think about how we enforce this policy.
I think, and Dr. Thomas, correct me if I'm wrong, I think there's a little form. Well, Nicole, you'd probably know. You have children in the system. There's a little form you sign on those devices, right? And
so we did, and I want to say the insurance policy was like $25, so it wasn't cost prohibitive for us. And just going through having the devices repaired, it's been a very smooth process. No complaints at all. I didn't know if they were issued these instead of textbooks and what it would look like if a parent were to say, well, no, I don't want to be responsible for that, so I decline to have my child issue something. How would the district make sure that child had material? But if these
I think that form, I'm sorry, I think that form says, and we might want to, you know, may or may not want to import some of that language here, but you know, it's only for like intentional or negligent.
Gotcha.
It's, you know, it's not normal wear and tear.
Do we want to add that word to this? I guess that's the code of conduct. Loss, theft, damage, and/or destruction of electronic devices will be the responsibility of the parents or guardians. So that does not reflect negligence.
I would like to suggest that we add that language just so it's very clear that the normal fifth grader not having a charger, not knowing how to charge it correctly or whatever, there's some assurance that parents won't be charged with some of the things they've encountered over the virtual learning period.
So Angela, do you want me to write that down, or are we gonna make that change here, Dr. Yeager, to add some language around that?
If you can do it on the fly, that's great, or we can just,
No,
I'm so sorry. Someone called me just now, and I'm sorry. Could you tell me what I'm changing?
oh, no, you're fine. We were just having a discussion about it, but I think we're coming up to the end. I think we should say something.
Can I jump in and suggest that we try to find that form that Nicole signed and all parents,
Okay.
and maybe just use that same language? And I may be wrong, but I'm remembering it has that kind of, normal
Right.
wear and tear accepted stuff in it.
I think you're right, and it may be that we don't even have to put that language in a policy. Maybe just attach that form as an exhibit. I don't know if it will work like that, but yeah.
Nicole, can you send that form to me?
I can try to look for it.
Who
It's
gives
the
that
best I
form?
have. But yeah, I'll try my best to dig through some emails and get it to you.
All right, thank you.
If it's not an instruction, it's probably over in Taylor's shop.
Taylor shop, that's what I was
Okay.
thinking.
Okay. Thank you. All right, we'll make that change and get that back to you guys.
okay, that sounds good. So should we move it forward on the assumption that it will be modified accordingly and then just leave it? Just assume it will be modified accordingly and then it'll be ready for the board at the next meeting?
I'm comfortable with that.
Okay. All right, so a motion to move it forward with the discussed amendments.
Second,
All in favor?
aye.
Aye. I wanted to welcome Dr. Gant. Thanks for joining us. Hope things are calm on your end again.
Well,
you didn't miss much, so we're just still on the first policy. So thanks for joining us. Moving forward to the next policy is JCEC. This is student demonstrations and strikes, and there's a reg that goes with it. It's 2 paragraphs, and then the reg has that repeated second paragraph repeated, and then a whole lot of details. I have some comments, but I'd like to open up the floor for any discussion by the other members of the committee first.
Nicole, you're
Oops.
muted.
Thank you. I didn't have concerns with the policy, but I did have some comments around the reg. So I'm not sure if it'll be appropriate to kind of share my concerns now or wait until we actually get to number 3.
I think we can handle them together.
Okay, could you show number 3? So my concern is that I felt like this needs to be a little bit more clear because I felt like it contradicted itself in a couple of places where the first sentence reads that the regulation isn't intended to discourage or prohibit peaceful expression. The rest of the reg kind of just details disruption, and a student demonstration or a strike, even if it's peaceful, is still a disruption. And it sounds like we're going to call the police or suspend and punish students if they participate, even if it's a peaceful demonstration, if it disrupts the school. And so I didn't like the way that felt.
And I totally agree with you. That was my comment. It feels like there's no room for peaceful demonstration. It's all demonstrations are disruptive and therefore not allowed. And
Yeah.
I'm just remembering, this is before you arrived, Dr. Watley, and pre-COVID, but there was a student demonstration about guns, not against the school itself, but about gun policy. And there have been some climate change demonstrations, I think also in the recent past. And both of those were very peaceful. And I think, if I recall it, the one at Cedar at least had permission from the principal to happen. The only really important thing I thought that they did do was keep outsiders from joining in. It was a student only demonstration, and that seems completely reasonable to me.
Agreed.
But aside from that, I would love to see something about how does a student who wants to have a sit-in or a demonstration of some sort and speak freely about issues that they care about, how we arrange for those types of things. I mean, that's my feeling, is that we need to make space for those, because that's a learning experience. It's not book learning, but it is a learning experience.
Right.
Dr. Thomas, do you have serious concerns about something like that, or is that within the range of what we can do?
I do not. I'm trying to recall. There were a couple of protests actually, like my first week in this position of being chief of staff. One was at Clark Middle, and I can't remember. I think the other one might have been at Cedar, and I can't recall exactly what the source of the one was at Clark Middle, but I think that, the staff did an excellent job of working with the students. We had things like they were going up too close to Baxter. There were some things, and I think within parameters of having safety. And the thing that we said kind of was, I think they kind of made it time limited, where they weren't, like, you can't stay out here all day. I think was kind of what the principal said, that we want you to express your opinion. But, after so many hours, I think they were encouraged to return, but they did a great job. They brought out speaker systems and microphones so that the kids could share their thoughts. So I do not have a problem with it. Now there was one, I think at Clark Central, where the kids were like running through the halls, and it was a safety, like they were just
Sure.
running out of classrooms and getting kids, they was like encouraging running through the building and things of that nature, where it just becomes a hazard to the safety of the students. But other than that, I do not see it being an issue.
So with that being said, do we need to, I guess, go back and make some changes to the wording? Sounds as if it is a disruption, in like an intentional disruption, or a disruption that's meant to be punitive. Are you all recommending that we go back and change some of the language here?
I am. I mean,
Okay.
I don't know if I could recommend that since it's a regulation, but I am concerned, and I would like, if it's something that can't be recommended, that at least it be considered by Dr. Thomas and cabinet.
And I guess in the policy itself, which would be within our purview, there's 2 paragraphs. The Board of Education charges the superintendent with developing procedures to handle student demonstrations and strikes that disrupt the normal operation of schools in Clark County School District. We could have another paragraph. Well, and then it says the board does not discourage or prohibit the peaceful expression or opinion of ideas, period. And there could be a sentence in there that says guidelines for peaceful demonstrations will be developed by the superintendent or whatever. What does that look like? And then have a third section that says the board is required by law to provide proper school facilities and maintain appropriate program instruction, But, or that last sentence could more focus on what I just heard Dr. Thomas say, which was parameters for safe time, time constrained, whatever you want to say, but that sentence would allow for that kind of a development of a regulation that accommodated peaceful, planned ahead, student voices that might not happen inside the classroom. They might be outside the classroom.
Can I jump in and say, I think, in a sense, what you're suggesting is actually more restrictive, if I'm interpreting it correctly. Because what's here is basically, that disruptive is the key term. That's the legal term for school First Amendment rights. You can exercise your First Amendment expression up until the point it causes disruption to the school and learning environment. So, and I think that's what, at least as I read it, that's pretty consistent in the policy and the regulation. So, if you prescribe, it sounds like what you're saying is sort of an extra step. And by the way, we'll consider anything disruptive unless you first register with us and get a permit, and you have to do it in these places and these ways. And, you know, that's, you know, heck, that takes all the fun out of a protest, you know?
I agree, and I think that, so, I think that the term disruption or disruptive could be very narrowly interpreted in the sense of, this is what the legal definition is. If we're looking at the statute, disruption of public schools, we have what that definition is, but in policy, disruption could be everybody wearing the same color shirt. Disruption could be.
And it's not. I mean, so there's no definition of disruption in the, you know, in statutes. It's, you know, First Amendment case law. So like there was a fairly recent one where, you know, a kid got punished somewhere in Georgia, if I remember right, for having a sticker on the back of his computer that said fire the principal or the superintendent or something. And so they and the court said, no, there's no evidence of disruption. It wasn't causing any problems. So you can't discipline him for that. You know, it really, in the cases, it's really on that case by case basis, you know, like, you know, Vietnam, a lot of it comes from Vietnam War protests, people wearing their black armbands versus Des Moines and that kind of stuff. And so, you know, if people are just wearing the armbands and it's not causing a disruption, we can't do anything about it. If people are wearing the armbands and they're burning the furniture, then yeah, now it's disruptive. So it really has, I'm not sure how you go beyond that to define it.
Maybe just some.
I was just going to say, you know, having my son be one of the organizers of the gun violence rally at Cedar, I know it was a complicated procedure for them to figure out what could they do that, you know, I mean, they didn't want to protest the school district. They wanted to make a point during the school day. So, and it was hard for them to navigate the rules, as I recall. So some clarity about the superintendent or her designee being the principal is encouraged by the board to work with demonstrations who try not to be disruptive or don't want to be disruptive. I don't know. It just feels like could be something where the students could be told, this is an okay thing to do. We want you to express yourselves. As it reads right now, it's very hard for them to navigate. So.
How about something more general, like students, I'm just thinking out loud, students who wish to have a peaceful demonstration or encouraged, I don't know that we can require, it's kind of, but maybe we can, but let's start with are encouraged to discuss it with school staff ahead of time, to put in place, you know, reasonable time, place and manner, guidelines for safety.
That sounds perfect. I love that.
I like that.
I got half of it down.
I'm cool with that.
I do too, Dr.
I would just, you know, ask Dr. Thomas to consider if there can be training or internal explanations of the word disrupt. I feel confident in everything that Mr. Pruitt just said, that if this went to a court, certain stuff will be ruled out. I just don't want it to ever have to get that far. So I want to protect the child who is not going to have the ability to take this all the way to court and make sure that he or she or they are not suspended without recourse for it. So I'm clear with what disrupt should and should not be and how it will be deemed. But if the teachers and the principals who will try to enforce this policy could have some clarity and examples of what disruption looks like and what does not look like or constitute disruption, I will be happy moving forward.
Okay. Angela, are you typing? I caught some of this. Students who wish to have a peaceful demonstration are encouraged to discuss with school personnel. And that's where I stopped. Dr. Yeager.
yeah, it was, yeah, that's about where I stopped too, but it said something about with school personnel to maintain a safe and what's the
Non-disruptive.
non-disruptive environment.
And then Nicole, what we could do on this end, let me write this down, is develop kind of like a flow chart, or I don't want to say flow chart, but for lack of a better word, this is what a peaceful demonstration look like. This is what one does, and we could give that to principals just so they can have like this is, some markers. Okay.
I like that a lot.
And then we can make that as an exhibit. Does that make sense? Okay.
I like that a lot.
Okay. I'm just making notes. 1 second.
And then they're learning. What does that look like? That's really, really important, right? Because we're getting all kinds of kids getting in trouble trying to have peaceful demonstrations, and they don't really know what that looks like, and they get in trouble downtown because they so I think this is highly educational.
Yeah.
Completely.
The flow chart's great. I think Nicole's idea of training for our principals is a great one, because, it would be, that's something I'd be willing to do, or we might be able to find some material, some NSBA. I think they have some stuff, or from ACLU. They've got a lot of stuff on student First Amendment rights.
Oh, wow. Yeah.
Sometimes we just put things in policy, and if it doesn't get to the principals, it doesn't mean anything.
Exactly.
I agree with that. I can get with you on that too, Mike.
Okay.
I wrote your name down.
All right.
There is somebody who comes to Cedar, I think, once a year. I can't remember who they are. I think they are from the ACLU, who talks to students about their rights.
Oh, that's great. Okay.
But I don't remember. Maybe if they're the same person all the time, or if it's just somebody that comes, might check with Mr. Derricott or.
Yeah, actually, on these First Amendment issues, I find, the ACLU may have a bad rap in some people's minds. I find their online resources on student First Amendment rights to be really balanced. They sort of throw in sometimes how they'd like to see the law changed, but they're very clear and accurate about what the law is.
Great. That's a good place to start then. Thank you. Okay, so does this feel, can we add this sentence, is that what happened? I can't really read it, so tiny. Okay, so we've added the sentence. Awesome.
Yes.
And then we'll just count on you to do the exhibit, which you can stick in and do without us completely.
Absolutely.
Okay, awesome.
And that can be a flow chart. That could be examples of what disruptive behavior looks like, what it does not look like, if you get with Mr. Pruitt. So whatever works, but I would be comfortable with that. I think it provides a lot of clarity for the students and a lot of clarity for the administrators who are actually at the schools.
Will do.
Awesome. Can we get are we ready? Any other comments? Dr. Gant, are you on board with us? We've lost Dr. Maddox. So Dr. Gant, you're now our quorum. She's still here.
Yeah, no, I don't have any additional comments.
Okay, shall we move these JCEC and JCEC reg forward for the full board?
I thought we were just going to move the JCEC, but then reword the regulation to define what disruption is.
Oh, okay. Okay, so we leave the reg alone. Okay. That's the 1983 one, though.
And this is being new and very green. So is it appropriate to move a policy up to the board and not move the accompanying reg up with it?
Certainly we can do that. Absolutely.
Okay, well, if that's the case, I move that we move up JCEC, student demonstrations and strikes, up to the full board for review.
Second.
All in favor?
Aye.
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 And then we'll kick the reg back to Dr. Watley? Is that what you want to do? So there's no way to write a sentence right now to make it work.
Well,
I don't think so, but I mean, I'm not stuck on that. I just feel like we need some clarity on what disruption is, and that probably would lend itself to changing some of the language of the reg. But that's, up to
Okay.
Dr. Thomas and Kathy.
Okay.
I mean, the alternative to that would be
Fine
to
with
leave
that.
the reg as is and just add the exhibit that would do that.
So we would provide the more specific guidance, Mike, in the exhibit?
Right.
Okay.
I thought that's what y'all were talking about, but I
did too.
misunderstood.
Oh, well, that could be. I could have misunderstood. So if that's what we're doing, then I'm fine with that.
okay, perfect. So we'll just add the exhibit.
I mean, so the thing about the policy and the reg is that they have the same paragraph at the beginning. So do we want to I don't know, I guess.
Well, okay, so I'm backtracking because I'm looking at number 4, and it says in the event steps 2 and 3 fail to stop the demonstration. That doesn't even talk about a disruptive demonstration, but the demonstration has to stop or police are going to be involved. I don't like that.
And I
Yeah,
think let's just hold on this one, and what
Okay.
we can do, Attorney Hall, if you and we can just go through this and kind of bring it up to a little bit up to speed, and we'll bring it back. Because I see what you're saying. It's like the spirit of it is kind of punitive. And so we want to kind of switch that around. So we'll work on it.
And the fact that it was last looked at in 1983 might have something to do with that. what was happening in our world in 1983?
I was born.
Well, I was in high school, and so I remember what was going on in 1983. It was quite punitive.
I was in high school too. I just remember a lot of really bad music.
Okay.
Fair enough. All right. So a motion to postpone JCECR1 for further work.
Yes.
So moved.
Second.
All in favor?
Aye.
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 Great. Thank you. All right. So JDA is corporal punishment. It is a single sentence that says corporal punishment shall not be administered to students in the Clark County School District. It was last touched in 1992. So this is one of the other ones I'm happy to update. Are we still following this policy, I assume, since it's review only?
Yes.
Okay. Any concerns or additions? Okay, shall we move it forward?
So moved.
Second.
All in favor? Aye.
Aye.
Okay, moving on to number 5. It's 5:04. I'm just watching the time. JDC is also a review only that talks about probation.
We were, this one was kind of tricky, Mike. We got kind of stuck. Nicole's like, yeah, we didn't know what probation we were talking about here. So,
I was hoping
I've been
for a
pointing that out for years.
oh,
So here's my understanding of fighting with administrators for my entire tenure about probation is I think they like to tell students you're on, double secret probation for whatever psychological effect it has. My point has been legally probation does not exist in the student discipline process.
mhm.
If we're going to throw you out for more than 10 days, we have a hearing on the charge. That's not, we don't revoke your probation. So,
Yeah.
Back when I was in the high schools, the term probation wasn't used, but it was the word chronic was used. And so like after, if a student had received several either write-ups And they were labeled chronic. Now, I don't know if that was like an official label, that was placed inside of their
That
campus
is.
folders.
Mhm. That
But
is. There's a whole section of the
Okay.
state law on labeling a student a chronic disciplinary. I
Okay.
forget that term, but there's a process you go through. I think that's all repeated and explained in the code of conduct.
Yeah.
Okay.
So, and that's been part of my pitch to, to get rid of this word probation, is that we have this thing called chronic discipline student and a procedure for how you deal with that. So,
Okay.
So can we
And-
just get rid of the policy?
I think
Yeah.
we should.
Just rescind.
Rescind.
Is
Right.
that what you've been
And-
trying to get us to do, Mr. Pruitt?
that's what I've been suggesting, but like I say, I don't know. I mean, Dr. Watley needs to jump in here and defend it if she and Sam think that it serves a purpose.
I didn't. That's why I didn't do anything with it.
Okay.
I didn't even know what we were, what was it about?
So Dr. Gant was about to say something and I interrupted you. I'm sorry. What were you going to say, Lakeisha?
I was going to ask, where is the policy found on chronic disciplinary policies or procedures? Because I don't remember seeing that in these under the discipline. And so it's not necessarily relevant for us to discuss right now, more so for my information.
I think it's in the code of conduct, JCDAE exhibit 1.
Okay, thanks.
Yeah, and I haven't found it yet, but when I searched for the word chronic, JCD came up and it looks like it might be somewhere in one of those laws that's listed under JCD. So I
Yeah.
haven't found it yet, but yeah.
It's also part
Okay.
of the JDE exhibit for the JDE for disciplinary hearing documents.
Okay. So Dr. Watley confirmed that we can rescind this one as is. Okay. Motion to rescind.
So moved.
Second.
All in favor?
Aye.
Aye. High five, Mr. Pruitt.
Thank you.
All right. Yeah, because that was my question. I was like, what is probation? What is it? How do we define it? So perfect. All right. JDF, moving forward, teacher's authority to remove students. This is also old, 2002. I found this one very confusing. It seemed to say that the teacher had authority to manage his or her classroom, discipline students, and then refer a student to a principal. But then it kind of ended up by, well, all they can really do is file a report, it seemed to me, but maybe I'm not understanding it right.
Well, this one, so it comes from a state law that was passed that year, and it hasn't changed since then.
Oh,
And it's one of those that sort of tries to summarize it without repeating everything in it, which is always difficult. So, yeah, I mean, part of that state law is that the teacher is required to make this report, and then there's more in the state law about the process of what happens after that. But it was intended to be a process to protect teachers. That was the General Assembly's thought at the time.
should
That was
we?
around the time, Mike, when there was like efforts to create that culture where teachers felt that they had some leverage in maintaining, I guess, a safe or effective learning environment. It was kind of during that.
That's right. That's exactly right.
This one,
Go ahead.
with this one, we're talking about JGF, right?
JDF.
ADF.
Oh, okay. Sorry. I had moved ahead. Sorry about that.
That was actually the one thing you missed. I think we postponed JGF, seclusion and restraint.
Oh, okay. Okay.
Yes, we'll be ready. We're Andrea Jolliffe and I are pretty much rewriting it. So we'll be ready next month to present that one. That one was not easy. Not as easy.
Yeah. So back to JDF, which is the teacher's authority to remove students from their classroom or manage his or her classroom, discipline students. So should we move well, I guess the parenthetical consistent with board policy seems sort of odd because this is board policy. Do we want to state which board policies we're referring to? It just doesn't seem very well written. So either I would
say, Dr. Yeager, just the teacher shall have the authority to manage his or her own classroom, just remove the consistent with board policy because this is the board policy.
This is the board policy, right? Yeah. I mean,
This is
presumably
it.
other board policies, but okay.
So to complicate it, I think that part adds a little bit of protection because we just talked about we're not going to use corporal punishment. So teacher, you have the authority, but you have to do it within the bounds of the other policies set forth by the board.
That's
So maybe
right.
we should
That's
reference
right.
those.
Because technically a teacher might say that, I was managing my classroom by restraining the student.
Right.
This was, maybe it was on a, continuum, but that was something that I absolutely had to do. And that would be in a different policy.
I would just ask that we reference a policy there because if we're going to keep that statement, because some people, we know what we mean in this committee, but for folks who are teaching in a classroom, they may not really interpret it that way. So to be clear, could we put specific policies that we were referring to?
We would need to list, we would then need to list all the policies because it's not just one, because there are several policies that govern discipline, behavior, and teacher interactions with students. So, if
Or could we just say policies that govern?
Yeah, so we would need to go through all the policies that actually, I just pulled 2 or 3 just by themselves that talk about respect from staff to students. There's one about communications with parents. So I guess we probably just need to set some parameters when we're saying, when we're saying reference a policy, it'd be multiple policies. So it'd just be a parentheses, which I think actually then would be consistent with board policy, kind of captures that. So
that's fine, either way, but I think when people see this, the immediate thing is they go to seclusion and restraint. When you're talking about removal of a child, because that means that you're putting your hands on a child. And so I in my mind, that's the policy that would be correlated when I see you shaking your head too, Nicole, to think about how, I just want to be explicit.
I just want to make sure that if we do list the policies, we don't miss any, because then technically then you're only given those policies as the ones, policy is the word, the language is what makes the policy. So if you put 2 or 3 policies, but you don't capture the rest of them, then technically those rest of them y'all didn't list aren't part of this policy. So I just want to make sure we don't miss, we just don't put it in there and then we're missing some by just listing 1 or 2. So we may just need to do that work before we just add 1 or 2 to this policy, is just what I'm saying.
So what if we added a sentence at the top that said other policies related to this policy, or I don't know, something like that, are blah, 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 and we list them, and then say within the guidelines of these policies, that the student or the teacher has authority to manage his classroom. Or, I don't know. What does the law say? Mr. Pruitt, should we just put in the law? What does the law say that we have to follow?
Well, the law on, I was just reading 20-2-737 and 738. They're ridiculously long. I couldn't fit 1% of it into the chat. I tried, but it rejected me. I went over my character limit. So, which is why I think it says, the last sentence says what it does, shall thereafter follow the procedure set forth in the law, and it references it.
I I like the idea of trying to be very specific so that people are informed, but I'm concerned about if we list policies, if we add policies in the next 3 years or 5 years or change policies and it's not on the radar to come back to this policy, like Mr. Harris said, if that new policy isn't listed, then there's not the responsibility of the teacher to follow it because it's not in this particular policy that outlines what they should reference. So I think, Dr. Yeager, you are right. It is a little bit confusing the way it's written, but that particular piece consistent with board policy, I think it sets a tone that the teacher doesn't have absolute authority. There are guidelines that have to be followed. So something needs to say that and stick out.
Yeah,
Can you say, oh, go ahead.
Yeah, I agree with that. I think the intent behind it, as I'm listening to Ms. Hull, I think that phrase was probably stuck in just to say, hey, this doesn't become your trump card that you can ignore other policies to maintain discipline in your classroom. You still got to comply with those too.
So what about saying consistent with other board policies related to teacher-student interactions or whatever, however you want to phrase it? Mr. Harris, you included quite a few in there. Or just say consistent with other board policies.
Other relevant board policies.
Other relevant board policies. Okay.
There you go.
Yeah.
May I, with this particular policy, as well as, I know we're not discussing seclusion and restraint, but really most of these, I think it's important to consider them in the context of the families and the students, as well as the teachers. And so I would, for instance, I know the past couple of years, not as much this year, but when school was in, some of us would get, when there's a flare up at a school, a discipline flare up, like I recall one school where there was this ongoing thing about discipline with one of the classrooms. This just seems to be an issue that I think has to be considered outside of policy committee. So I would be very curious. I'm not saying that has to be done today because I know that a lot of these we really are trying to review for the sake of reviewing and updating. But I really do think this is an area, given what we know about disproportionality and what we know about administrators and teachers. Most people have very strong feelings around discipline, and parents. And we also know that it's important to consider policies not just in a vacuum. So not just like the school district or at an administrative level. So I'd be very curious in the future to hear what teachers think, be that through the teacher advisory board or the parent advisory board or some of the boards and advisory committees that we already have set up, from students as well. Because these policies eventually, while, we are wordsmithing, there's still a lot of latitude, and we still have some policy recommendations from Dr. Welch's report that I think at some point would be helpful for us to, not us as a board, but really us as a community to figure out where we're going with that in terms of equity and exclusionary discipline and things like that. So even if not now, I just wanted to, for the record, mention that so that as we're going into next year, getting ready to do the code of conduct, and when we do have time, to look closer at these policies, and we're not trying to really just go through and update them, that we include some other voices.
Well, two things have been done this year, Dr. Gann. One, the discipline task force, we sent out a survey for the administrators to complete regarding discipline in the student code of conduct. And then this week, the survey for teachers went out. And so the data that we'll get from that will inform the decisions for next year's student code of conduct and discipline. And hopefully some of the questions in that survey will speak to this. And if not, we can always enlist, send that out in a subsequent survey before next year. Does that make sense? We're going to be reviewing that data in May. The discipline task force will. So we are asking those very questions to see if there is even variability interpreting things such as this, from elementary, middle, and high to, getting down to some of that root cause and explanations around the differences in how people interpret the policies as well as the student code of conduct.
Right. Great. Thanks for that update.
So with that being said, is there a way to have this policy only address the teacher's authority to remove students from the classroom? That's it. Not to discipline them, not to do anything else, but just their authority to have a student referred to the principal's office, essentially. Because I think that's what the descriptor code says, but it seems like the policy goes more in depth. It's broader than that. It talks about the ability to discipline students and filing reports and stuff. I don't know. Are we just trying to say, teacher, if the student is disrupting your ability to teach, you can send them to the principal's office, or are we trying to do more than that?
So in the law, and this is in 738, so paragraph A is where that managed class, and actually that's where consistent with local board policy comes from. Teacher shall have the authority consistent with local board policy to manage his or her classroom, discipline students, and refer a student to the principal or principal's designee. I'm not sure if we actually need that part though, because I think subsection B and the rest of this very lengthy statute is talking about the teacher's authority to have a student removed. And so I think that was the, like Dr. Thomas was saying, I think that's the intent here. So there's this procedure. We probably never use it in Clark County. Probably nobody does, because, a teacher is going to work with the principal. But this was sort of what it gets at is that you as a teacher can get that kid out of your class for at least that moment and for one day, even if your principal doesn't agree with you. And then there's this whole process of notifying the parents and having a review committee and all sorts of stuff that's in the statute that's not repeated here.
That's interesting.
That's interesting.
That's not what this policy says.
Okay.
Well, if you took out this first sentence, which again is part A of 738, but if you took out the first sentence, then you're just talking about the removal.
Well, that doesn't actually say removal. It just says shall file a report.
Well, and then thereafter follow the procedures, which are for removal.
Oh, well, so that's not in there very well, is it? I mean, how would you know you could do that?
Stated very well. And I mean, I tell you, I can't deconstruct these statutes on the fly here.
Yeah.
I'm not sure anybody knows what they say.
Okay. Well,
maybe we could just say a teacher has the authority to remove a student from his or her classroom in accordance with OCGA 737 and 738.
boy, that's kind of sweet and simple.
I like it.
I like it.
Can you say it one more time, Mike?
Yeah. A teacher shall have the authority to remove a student from his or her classroom in accordance with OCGA sections 20-2-737 and 738.
That makes sense.
Did you get that, Angela? Yep.
are we deleting the rest of the policy?
Yes. I think so.
Mm-mm.
I like that.
Yeah,
And we need the part about the reg, because is there a reg? I don't see a reg. Was there a reg?
I don't see a reg.
Oh, here's where the thing, so it 737 does say local board policies shall require the filing of a report, blah, 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 the rest of that sentence. So that's why that sentence is there with no other explanation, because that's the one thing the law says we have to put in there.
Okay. So we need part of that back then, you're saying.
I think so. Maybe I can. I'll
It's
just put this
just,
one sentence.
It's just the shall file a report of such behavior.
Maybe I can get that one sentence in the chat.
Yeah, Lawrence says there is no reg. So just say teacher the teacher shall file a report. Such teacher shall file a report. With,
Yeah, maybe we have that first sentence, that new sentence we wrote, and then we follow it up with a teacher who has knowledge. So just get rid of, start with where it says the filing of a report by in the chat, get rid of that, everything before that, and just start a teacher who has knowledge that a student has exhibited, blah, 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 shall file a report.
any teacher or the teacher?
The teacher, that's good.
The teacher who has knowledge that a student has exhibited behavior which violates student code of conduct and repeatedly or substantially interferes with the teacher's ability to communicate effectively with the student in his or her class, shall file a report.
Yeah, shall file a report as required by law. Or
Do we need
required
all
by,
of the gobbledygook between violating the student code of conduct?
let me see, let me get back to what Angela is working on here. Blow it up so I can see it. Oh, get rid of that.
I mean, I guess all that stuff is in this.
Teacher. Yeah, that's fine. I think if we do the way we've got it there, it's fine.
Okay. And then the last question is, do we want the administration to develop a necessary regulation to carry out this policy?
I don't see in the statutes that anything further is required on our part.
Okay, so we can delete that. And now you're back in compliance, Dr. Thomas.
Do you see me leaning in? Going from this version so I can see you all to where I have it actually up on my computer where I can really see it.
Right. If you reload, you get her edits though, I noticed. If you reload it, you have to re-enter it.
Oh, okay, okay,
You'll get her updates anyway.
okay. I can go back
Semi-live.
to board. Okay.
I like this one.
In that sentence, a teacher has the authority to remove the student. Should that be a student? The highlight, the sentence we added.
Oh, student, yeah. A student. Yeah. Okay.
Yeah.
Yeah, I like this
Yeah.
better.
I think so.
And it actually
do
talks
too.
about the real what they're allowed to do, remove the
Mhm.
student rather than some hemming and hawing about managing their classroom. Okay, cool. Everybody okay with this one?
Yes.
Yep.
Motion to move it forward?
So moved.
Second.
All in favor? Aye.
Aye.
All right, it's 5:30. We're skipping JGF. We're moving to JGFB, supervision of students. This was recommended for review only. It's just a couple of sentences, 3 sentences. Principals and teachers shall exercise appropriate supervision of students in order to maintain discipline and assure safety. Then there's comments about what happens if they become ill or if there's an accident. Seems pretty harmless.
Yeah, I didn't
I thought that it was pretty
have
straightforward. So.
Okay, and I like it's sort of appropriate supervision, so it's not like you must stand out there all the time watching them. Okay, shall we move forward?
So
Mr. Pruitt, did you have any comments?
I was, well, I noticed one, and it's no big deal, but in the second paragraph, did the next of kin strike anybody else as
Yeah, it kind of rubbed me funny.
morbid?
old fashioned.
In the event the parent cannot be reached.
The emergency contact would be notified. Don't we have emergency
Yeah.
contacts?
Yep, you beat me to it. I was unmuting to say that. I like that.
Emergency contact.
I was struggling with next of kin as well.
How about we just, so I guess, so is there always the parent is supposed to be the emergency person? I mean, aren't there students who have guardians and non-parent emergency
Yeah, we could say
contacts?
Parent or guardian cannot be reached.
Did you get that, Angela? Parent or guardian? In the second paragraph.
Second, yeah, there you go. Second sentence in the second paragraph.
Nope. Up, higher.
There you go.
In the event the parent
There you
or
are.
guardian. Don't we have some policies somewhere though about like medical treatment for emergencies? I thought we did that one.
Are you talking about first aid? Or?
Well, no, the first aid one is nothing but AEDs,
Yeah.
which is kind of ridiculous, but yeah, we don't have a first aid.
Yeah, I think we did something with like student administration of medication or something like that. Is
Oh
that what
yeah,
you're
yeah.
referring to?
Well, I'm okay with this one, although, yeah, I don't think it accounts, well, if the injury is serious enough to warrant medical attention, the parent or guardian of the child will be contacted by the office. Yeah, I guess there's, I mean, to have all that stuff, medical stuff in the supervision of students seems a little bit
Right.
strange anyways. That's not the place to put all that stuff, I think.
And
mean,
it's kind of
ideally-
awkward. It's subjective regarding warranting medical attention. So are we saying medical attention, i.e. contacting 911 is the only time, or is medical attention going in the clinic to give a Band-Aid medical attention? Is it getting ice from the, it just caused me to have a lot of other questions as well.
Yeah. it seems a little odd to have these two sentences in the policy
Mhm.
with the supervision. Like, it seems like that's what struck me as odd, along with the next of kin, of course, but I guess I wonder if we have those words in another policy, and I apologize that I didn't follow up on that query. I mean, we can leave them in there, I guess. But let me see if I can find.
The only thing I would, again, just ask Dr. Thomas to consider is if there's some confusion over what medical attention is, just flesh it out. Because when I read this, I think Google report. So if my kid has to get ice or there's a severe scrape, I'm looking for a Google report where somebody else may say, well, there was not a need to call 911 or there was no serious injury. So
Yes.
Makes sense.
So student,
Can y'all hear me? Because I'm not sure what's happening.
we're thinking, we can hear you.
I can't hear you as well as I
I'm
was
in my
earlier.
car and I think I got a telephone call, so I didn't know if it kicked me off of Zoom or not. So sorry about that, if there was a pause on my end.
I just turned you up a little bit, no problem.
Thanks.
So I'm just kind of skimming through policies that use the word medical. And Lawrence just stepped out, so I mean, I think we do need something about what happens when a student gets ill and what happens when a student gets injured. If this is the only place it is, I don't think this is adequate, and it seems like these should go in first aid anyway. Although I understand legally, if they're hurt and we are supposed to be supervising them, right? You can't just like hand them over to the hospital without some kind of I mean, I don't know how that works legally. Giving up supervision to some other authority if they're hurt or sick.
Well, I mean, we're in loco parentis, so we have the authority under that principle to make sure students don't die. But, we're not going to authorize. In loco parentis doesn't let you authorize elective procedures, but it lets us act in case of emergency if we need to. And that may be why, I mean, I'm looking through my list of required policies and I don't actually see that anything on that is required. And that's probably why, because that's understood by the in loco parentis principle.
Okay. Well, then we just leave it as is then? Or Dr. Thomas, did you want to try to strengthen it a little bit more? Or do you want to put that in a regulation about how we do that stuff? And then
We can make a note, Dr. Watley, that we might want to look at it for a regulation.
Okay.
okay. Any other concerns or comments about this one?
Not on my end.
Shall we move it forward?
Yes, ma'am. So moved.
Second.
Okay, all in favor? Aye.
Aye.
All right, 5:40. Getting there. JGFC number 9 is about dismissal precautions. all students are required to remain at school at all times during school hours unless permission is granted by the principal or designee. And then there's do not give to anybody that doesn't have authority to take the child, release of the student. And release to student of officer of the law. This says we only with a subpoena, which is, I presume, consistent with our other policies, right? Not allowing.
It is, and we made changes to LDAJA and we referenced it here.
Okay.
Parental contact to be made.
I was curious, the only comment I had was about the word permission. How is that different in every school, how that works? I don't remember ever, like if a parent has a doctor or a kid has a doctor's appointment and you pull them out of school, who's giving permission at that point?
So if the kid has a doctor's appointment and they're being pulled out of school, they would be pulled out by a parent.
Right.
Unless, and that is checked in campus, unless, you know, they have to send grandma or somebody with them, and then they always have a note.
Have a note.
There's a note that's generally sent earlier in the day, and, you know, depending on situations, they may call, you know, there's a phone number, we'll call, we'll follow up. In cases of emergencies, we've had situations where someone has had to come, and so we would just make an effort, you know, without a note. So we would make an effort to contact the parent based on the number we have in campus to confirm that that individual does indeed have permission of that parent to pick up that child. And, you know, extra precautions are taken. So, I mean, like sometimes I would have someone say, well, I'll call them on my cell phone. And I'd say, no, I'm sorry. I have to call them from my phone with the number I have in campus. And,
Right.
you know,
Sure.
to confirm that that is who they say it is. And so I think those are more operational pieces that, you know, leaders do that wouldn't necessarily be in policy, but it
Okay.
would be based on who's in campus and having a either an ID, or if it's a parent, you know, that's in there all the time and the receptionist knows them, then of course.
Yeah, I was about to say, I think the person at the front desk is the principal's designee.
Mhm.
Okay.
Put it in the terms of these policies. I mean, you don't just
Okay.
you can't just go into school and walk out with your kid without checking in with the front
Right.
office. That's what
Absolutely.
that means.
Okay. That's good. So that clarifies what it, right. Okay. Great. All right. Any other questions about this one? Mr. Pruitt, you're okay with it, obviously?
Good.
Yep. You want to move it forward?
So moved.
Second.
All in favor? Aye.
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 Okay. JGFGA and its reg are both from 2008, and they are exclusively about AEDs, which are devices used for people having a heart attack. Seemed a little narrow to me, but maybe that's just me.
We did review this one with Amy Rourke, and she said it still stood, and it was fine according to her. So Mike,
Okay.
I don't know if you see anything different.
Yeah, the state law requires us to have this policy, and my guess is that this is where GSBA told us to put it. So on the AEDs.
Okay. Any other comments or concerns about this one?
Sorry.
Not for me.
No.
All right. Shall we move it forward?
So
It and
moved.
the reg move both forward, excuse me. Motion to move both forward.
So moved.
Second.
Okay. All in favor of moving forward number 10 and 11, JGFGA and its reg, say aye.
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 Okay. JGGA, titled Walkers and Riders, we recommended to change the title. Mr. Pruitt, are we allowed to change the title of these things, or we get into trouble when we do that?
Well, it's not a matter of allowed to. It's just that I think technically the GSBA assembly system won't let you do it. Now we can do it now because we're using board docs. We may have to change
Okay.
it back if we change back to assembly.
Yeah, well, I think we consulted with Mark Weaver. Nicole, you have to remind me, we had so many policy update meetings, but Mark was, he wanted that to be changed, but if we cannot change it, that's fine. The content of it is what we had to kind of work on the language a lot more with this one.
I mean, we can change it now. We just may have to change it back.
Okay.
Yeah, that's what I remember, Dr. Wiley.
Okay.
Okay. So this was a very nicely worded, I thought, authorization to use buses to transport students. Seems fine to me. Any other questions or concerns about this one? Mr. Pruitt, did you review this one?
I did. It's fine. The QBE funding is actually for students who are 1.5 miles more. So
Yeah.
we'd have to do it at least 1.5, but we've got 1 mile in here, which is more. So that's fine. Picking up more students. And of course, QBE doesn't fund much of your transportation anyway, as you know.
Yeah. Okay.
For this one, I know that it's typically, or I think I recall that it's a practice that if a student lives within that mile, that there are some efforts to get the student there. I guess I just worry about students who may live within a mile of a school, but there may not be infrastructure for them to walk to school. So if something happens where their parent can't get them to school, or their guardian, or if they're sick, or, really anything. And I don't think that's many of our schools. I don't even know if it's any of our schools. Cleveland Road came to mind because it's, those schools that are further out. But I just wonder, even if we, it can't be represented here. I don't know if you can speak to general efforts that are made for those students, or do we even have that many cases where that's an issue?
I think we can follow up to confirm that, Dr. Gant. I know in areas where it's less than a mile, but still dangerous for students to walk, transportation has just made accommodations, like when you talk about like the Cleveland Road area and there not being sidewalks or, safe space for students to walk in. They've made accommodations. My worry has been a lot of times kids walking to Alps and it's raining. That's just it's just hard for me personally. It breaks my heart. Yet I know that's, standard practice. I know it's policy.
Is there a bus that goes to Alps though, Dr. Thomas, well, I guess that would be within a mile radius, but I'm thinking of like Columbia Brookside, as well as even that Beechwood area, although I don't know how many students we have coming from over there.
Right. So I think Columbia Brookside.
That may be more than a mile,
Has
actually.
a bus, yes. I just think about some of the ones coming down Baxter Street. It's what I was thinking about. So I need to ask Mr. Weaver about some of those areas.
And I know it puts them in a strange position, especially since we don't get a lot of funding, but I really just think about the students for families that really just may not have resources. Like if parent is working, it may be infrastructure like sidewalks, or it simply may be that no one is there to take them to school or able to, and they may not have that support system when something happens, or it could just be a day-to-day part of their lives. Like if they don't leave at a certain time to get up and come to school, then it's just sort of over for that day. Or if they miss the bus, or thinking about those outside of the mile, but within the mile, it just sort of, it is worrisome, but I just don't know if I'm, worrying about a problem that really we have encountered a lot.
Yes, and I'll make a note here to ask Mr. Weaver about that. And I can get back to you all.
Do we want to add something to this nice paragraph about provide the board, the policy of the Board of Education to provide safe transportation to school, or safe, is there other word besides transportation, I guess? And then have the 1 mile thing be kind of the guideline, but not the rule. Or I guess there's nothing in here that prohibits us from helping someone who lives closer than 1 mile get on a bus, right? There's nothing that says we can't do that. So
That's the way I read it.
Yeah, okay. So just leave it be.
Yeah, I would say leave it be, but I am very curious about, if this is an issue, particularly for our smaller, or for all students, but like our elementary school students. Like I said,
Yeah.
maybe imagining this, but I know when I used to serve Cleveland Road, it feels, rural, although, but I don't remember there being a mile of sidewalks there. And there may be other schools that's the case, but I'm just not sure.
Yeah. Okay.
Maybe 4th Street, some areas of Stroud or 4th Street. I really just can't remember.
I'll get that information.
Okay. So just let us know if we want to update this a little bit once you get that, but it seems like it doesn't prohibit doing that. Okay, do we want to move this one up? Any other comments or concerns?
Not on my end.
Okay. Shall we make a motion to move it up?
So moved.
Second.
Okay, all in favor of moving up JGGA for consideration by the full board? Say aye.
Aye.
Aye. Okay. JGI, child abuse and neglect. The policy is currently recommended for just review only, but the reg has been edited and revised.
Yes.
Did you want to discuss some of your changes? Dr.
Yes,
Watley?
we absolutely. In child abuse and neglect for the reg, we changed some of the language to clarify the role of the investigator in the forensic interview process on CCSD school property.
Yeah, okay. The policy itself remains unchanged. I had a question about the ACC Abuse Protocol Committee. That still exists, I assume?
Yes. As far as well, Dr. Thomas, is that the?
I'm not sure which. I'm trying to look at.
Hold on.
Yeah, it says the superintendent or designee shall serve as the Board of Education's representative on the Athens-Clarke County Abuse Protocol Committee.
Yeah.
Yeah,
Since
Dr.
this
Meyer
was-
served on that committee, so I assume Dr. Watley would be serving on that committee now. I actually went to some of those. It's just a lot of different agencies and representatives of the community. And it's actually statutory, and it's under the auspices of the district attorney's office.
Okay.
And we have a community with a meeting with them, but it's around attendance and school climate. We met with them last week, and that's under I think the DA or DJJ, juvenile court, I think. And we had that meeting last week, but I have not received any communication around this committee.
Yeah, there's an attendance protocol committee that the juvenile court does. But there's also this child abuse protocol committee that is statutory. So yeah, you probably want to follow up with, I know they always met, I assume they still do, at the cottage. Staff there might be the people to get in touch with and make sure you're on the list to attend those meetings now.
All right.
Unrelated, does the attendance protocol committee still meet? Is that something that we're supposed, well, let me just say, I haven't gone to any this year, so maybe I've missed them, but.
Was this one internal?
No, this one was like one that, well, I don't know that forced is the right word, but I felt like I was told to go to, and it was some type, because of some type of legal something or another, but it was not internal. It was before, I think Dr. Means and one of the judges, but then it was different people there. It was
Yeah.
it was like a lot of law enforcement people and school people.
And I've never been to one of
last
those,
week.
Dr. Gant, but the juvenile court has and it's not really by law, but I think it's from what I hear, it's worked well. There's what they call an attendance panel. And so it's sort of a
Okay.
preliminary step before we take a parent to juvenile court for neglect, for not sending their children to school. The juvenile judge will convene this attendance panel to, review the case and try to get the parent into compliance.
But I think what Dr. Gant's talking about is what we met on last week, but they didn't mention that the board president had to be there. It was an attendance and school climate, like community
Yes.
group that's supposed,
Yes,
and they
it was
That-
Monday, Dr. Thomas.
Yes. Oh, well, that was this week.
We met
God,
Monday
it's been
with
a
them.
long week. Oh, God. Okay, yeah, and we met with them. It was Judge Trimble, and
Yep.
there were people from DFACS and the DA's office and some other folks, and they're going to be convening. Again, they asked Dr. Watley to pull some attendance data, and we're pulling some school climate data. Crystal Gillis was on there. And I think that's what you're talking about. It was like a
Yeah, I'm
county-
looking at it now. I was just trying to figure out who told me I had to be there.
Do you know
'Cause
about
I
that
had-
one, Nicole? You're plugged in.
So I'm wondering if it's either the one sponsored by the nonprofit or if it is the stakeholders meeting. The stakeholders meet every month. It was at the DFACS office, but all of the juvenile court stakeholders will meet. But there was also recently a conference or a presentation by one of the local nonprofits that brought a lot of the stakeholders together to talk about juvenile justice. So I'm not sure. I do know that there is kind of being some clarity around how to deal with attendance, whether or not our juvenile court is really going to look at it or define it rather through truancy or through ed neglect. So I think there's going to be some movement and talk around that shortly on the horizon, but I'm not sure which
Oh,
one
I
it is. I
found
can
it.
find out.
I
This
just
one
found
is
it.
It's under
What does it say, Dr. Gant?
OCGA. It's the OCGA mandate 20-2-690-2 that requires that every community have a school attendance and climate committee, and it comes from.
I'm sending that.
Mm-hmm.
Yeah, I just sent it. It was like something. Yeah, Dr. Tom, sorry. Yep, it was that statute. I was trying to figure out the original email.
So it's a little different than what Attorney Hull and Attorney Pruitt are talking about. This one hasn't met in a while. You're supposed to develop a attendance protocol for your community. They started meeting right before Dr. Means left. I went to one meeting, then COVID happened. They haven't met again. So they're starting back up, and we're going to come back together, I think, in June. Yeah.
Okay.
Can I pull us back on track?
Yes.
Sorry, because those meetings are not about this, are they?
No,
Are they?
they're not.
All right, thank you. I'm going to try to get us back on track because it's 5:59. So JGIR1, Dr. Watley, the wording of the third paragraph seems odd. I just typed in what I think it is after the scratch outs are reviewed. I just put in the chat. It says investigations, which do not to include forensic interviews of students who are victims of suspected child abuse, which interviews occur on school property. There's something wrong with.
Yeah, let me read that.
It doesn't have an object.
Yeah, I think the intent of that was to just make sure that investigations that do occur on school property do not include forensic interviews.
Investigations that occur, hang on.
Not, just say not to include. Not to-
investigations that occur on school property
Mhm.
will not include forensic investigations of students who are suspected of child abuse. Did I get that right, Nicole?
Not a little bit, not because I'm trying to look at it. So the child isn't suspected of child abuse. And Dr. Watley, were we saying that they do not include or they will not include? The point behind it was there were forensic interviews being conducted by DFACS on school property to kind of work around that parent notification piece that they have to do. And so the reformatting of the language was to make sure that there wasn't a workaround, that if DFACS or anyone else needed to do a forensic interview, then that was not to be considered an investigation, which is very different under this policy and under the law. Does that make
Okay.
sense?
That makes
Yeah. It's just that the two which phrases don't make sense. So I think if I heard you right, so I can't quite read what Angela's doing, but investigations that occur on school property may not include forensic interviews of students who are victims of suspected child abuse. Investigations that occur on school property, and there doesn't need to be a comma, may not include
forensic interviews of students who are victims of suspected child abuse.
Is that what you meant?
Yes, it is.
Awesome.
And so we want to kind of protect the students to those types of forensic interviews, have a place.
Totally. Yeah,
but,
totally.
Just not on school property.
Yeah, I just couldn't get that from the sentence. I'm sorry.
Yeah.
Great. And okay, good. All right. So shall we move these up? And then we just have the last three, which are review only.
So I just have one itty bitty comment. I promise not to be brief. So in the regulation around that, the school does not notify the parent. Can we talk about why? Because I understand some of it, but can I just have a clear explanation as to why, if the DFACS social worker comes to interview a child at school, we aren't notifying the parent that that's happening?
I think that was because of the investigation getting mucked up, but go ahead, Dr. Watley, sorry.
Well, I think that when we talked about it, Nicole, and maybe we need to clarify, but if the parent is the abuser, we don't need to notify that parent. But that's an assumption because sometimes that's not the case. I would like to, are you proposing that we kind of clarify that a little bit? I'm assuming yes.
I'm just kind of going through it. I definitely understand that if a parent is the abuser, we don't need to alert them so they could coach the child. But if I'm in that role of a parent and my child comes home and say, hey, I talked to DFACS today, they talked to me about X, Y, and Z, and nobody tells me, that might get a little sticky. So I'm just trying to process it with everybody to figure out what are your thoughts and what is our role. Because I don't think we have to notify.
I'm sorry, I'm reading.
Yeah, there's a federal, well, Nicole knows there's federal law on child abuse too that, exempts notifying the parents if the parent is a suspected abuser. I read that sentence just to say we leave it to DFACS to make that call as to whether the parent can safely be notified or not.
I got you. I'm probably just overthinking it because it could be that somebody else is the alleged abuser, but we're still not notifying the parent. But I might be overthinking it. I think the way that it is read, that maybe there's some discretion for situations like that where the school can notify the parent if it won't put that child in danger without putting the requirement there. Is that how y'all are reading it?
I agree with that.
Okay, well, in that case, I'm fine. That alleviates my little concern.
So now I'm confused. I'm sorry. It says Clark County School District officials should not, as a matter of course, disclose to parents or family members of a child that a child abuse report has been made to DFACS, as this could jeopardize the investigation process. That's pretty do not as a matter of course. There's not a lot of flexibility in that.
But so as I read it, that is in terms of the actual report, but not the investigation.
Okay.
So what I'm thinking is if child goes to school and discloses that uncle sexually assaulted me, and it's very clear that it's not the parent, the school will have the discretion to be able to notify the parent if it's determined that it will put that child in danger. And that would be very different from saying, hey, parent, we just called DFACS on you because you sent a child to school in 20-degree weather with shorts and flip-flops on.
Exactly.
Okay.
And to take it a step further, sometimes there are DFACS reports because there's suspected abuse by a district employee or by another student. And in those cases, we have to tell the parent under Title IX. So.
Okay. Okay. So the sentence that says it's the responsibility of DFACS worker to notify the parent caretaker that his child was interviewed at school. Okay. Okay. All right. Are we all good with this one then? This one and its policy and its reg, JGI and JGI Reg 1. Dr. Gant.
I know this is sort of a thin line here, but I just want to be sure that I understand the reg. So if a counselor or psychologist suspects or has reasonable cause to believe that a child has been abused or neglected, what this is saying is that the expectation is that that psychologist or counselor, who are also mandated reporters, but have some different guidelines, that they contact the principal first, or that they contact the principal in addition to having the autonomy to contact DFACS as well.
I'm guessing, and Nicole may know, that there's some additional documentation that teachers get about how they do this. I remember under the law, so a teacher can satisfy their obligation under the statute by telling their supervisor, the principal, and then the principal's legally obligated to make the DFACS report.
Right. And but therapists and counselors and psychologists, I mean, is that enough for them to simply notify the principal?
Well, I know that as a procedure, as a support personnel, to notify some districts will outline a procedure for support personnel to notify the principal, but also their direct supervisor, which may be a central office employee. Because
again, I'm sorry.
Because
are you asking if you have a requirement that makes you a mandated reporter outside of the school district? Are you going to be subjected to a misdemeanor if you only report it to the school? Is that what
That's right. That's right.
Okay.
So as a licensed individual, and I know not all of our psychologists or counselors may be licensed, but yeah, it's very different if they are, well, maybe not, but I'm just thinking of our code of ethics. And
are you referring to outside psychologists, outside of the school district, outside therapists?
I mean, like those that are working in the schools, like, okay. So if a person is licensed as I don't think we have, or I don't know how many we have now. I know we have a few LPCs, but whether they're licensed or not, I guess I'm thinking more along the lines of the code of ethics for social workers, for counselors, and for psychologists. Does this put them in any type of, I don't know, like ethical,
like
does it put them
in?
Well, now back to the same thing. I don't see anything here that if you have some independent duty to make a direct report, I don't see that this prohibits you from doing that.
Okay, that's my question.
Right.
Okay.
Right.
So Dr. Gant, do our psychologists, so how does that, I mean, if that's the case, then I think Dr. Watley, we need to look at our practices, even if it's not policy. So if
Exactly.
you are a mandated reporter, our schools have a process where you have a identified individual in the building that is the designee that makes all reports. So we need to look at, I mean, if that's the case, then I guess we need to look at what our practice is, because I don't know if we would want like this. If so, let's just say it's the assistant principal or counselor, whoever's on site. So then the counselor makes a report. So then are we saying that the licensed psychologist would go behind them or ahead of them and also make the report?
That's what I'm asking. And I would probably, it would probably take a little bit more time for me to look back through our code of ethics, as well as counselors, and then school counselors have their own code of ethics too. But I just want to be sure that like in our code of ethics, if it bumps up against the law, it encourages us to try to resolve it still within the context, or maybe not the law, like the practice of that organization, the policy of that organization. I think it encourages us to try to resolve it and still handle it though within our code of ethics, if at all possible. And so I just want to be sure that there is nothing that prevents those individuals from being able to make a direct report if they have to, because
so the way I read it is just that once you've made that direct report, you also need to notify the principal or the principal's designee in the building.
Right.
And then what that building person does, I mean, frankly, if I were that designated person in the building, I'd probably follow up with defects and not just take your word for it. To make sure my responsibility.
I agree with that. So what'll happen, Dr. Gant, so if I'm in that situation because I'm volunteering at a school, then I would have to let the school designee know, but I would still have to satisfy my responsibilities as a mandated reporter by making the direct report. And what will happen is it should all go to intake and be flagged together. So it won't be a duplicate report, but they'll note it the same way because the same people will be involved. So I would just, I'm not giving you legal advice, but I would say just make the report. Nothing's going to prevent you from making another report.
Right. And I just wanted to be sure that there weren't, because it could be a case that a psychologist or counselor makes that report to a principal, and that still doesn't cover them ethically, or maybe that principal decides like, yeah, no, because there's a level of discretion there.
Right. This says there isn't really. The principal shall immediately, but in no case.
Reasonable cause is the discretion, and it's a bugaboo. It's within 24 hours, from 24 hours the time there is reasonable cause to believe.
And I'm not trying to slow us up, but this actually came up one time when I was in the district with a counselor. And so since then, I was like, yep, nope. I'm just gonna, I always felt there was our obligation to call defects directly and make a report anyway. But when this situation came up, I think that there was something around, I don't know if it was this particular policy, but it was the expectation that, that the principal or whoever they had told was going to make the report. So I was just curious, just trying to be sure that those psychologists, counselors, and social workers who are also mandated reporters, but have, that may have something within their code of ethics or just, best practices to directly report abuse, are not prohibited. But I also hear what you're saying, Dr. Thomas, that it would definitely be something, if it is, that may need to be more conversation around. I just want to raise that concern. I'm not, because I do understand this is a regulation. But I wanted to raise that concern for consideration.
What I can do is I have a team meeting this week, and this is a great topic for me to raise up to my directors to see what the practice is currently. I know that when I was in school as a psychologist, we were advised from the district as a protocol for student services to notify the principal, but we could make a direct call, but we had to notify the principal. It was just very clear.
Okay,
Here,
okay.
I'm not necessarily sure, so I would have to talk to my directors to see what's going on in practice. But I have worked in districts where they're very clear about, you know, the process in terms of making those defect calls.
Just practically speaking, Nicole, you're the expert, but I'm guessing DFACS would prefer not to have multiple reports. But if people feel like they need to make multiple reports to make sure they're covered, we're not prohibiting them from doing that. Is that fair?
Yep. And I think, Dr. Gant, just thinking through it in that situation, it may be a best practice for you to notify, because there is some discretion. And the example that we use teaching mandated reporter stuff would be if a child says, I'm hoarding bananas because my mama didn't feed me last night. A principal may say, well, you know, I talked to your mom. She said she cooked mashed potatoes and you said you didn't want to eat them, and that was your choice, but you had food, and could decide to screen it out. So, you know, I don't know the internal process or regulation for Clark County, but I would think best practice would be to just alleviate it. Make that call. They're going to ask you for the details and for your contact number anyway, and I'll put it in their Shines database and flag it as being the same report.
Right. And I guess it does open up a larger issue, right? You know, is everybody being mandated reporters? I'm thinking in schools, you know, I was just speaking specifically about those counselors, psychologists, and social workers. But then, you know, does that open up the door for all staff, and, you know, understanding the disproportionate referrals that go to DFACS often, that put families of color in situations sometimes where behaviors are misinterpreted. I don't want to create any unintended consequences. I'm just more so curious that if a psychologist or counselor or someone does make a direct report, not that they wouldn't tell their principal as well, but are they outside of, is that considered insubordination or outside of policy or what have you?
Gotcha.
I understand. I will, let me do a little fact finding on this. Dr. Huggles, you asked a very crucial question, and I have worked in school districts where that was clear. And I can't answer that right now, but I'll definitely meet with my people on Tuesday so that we can figure out what's going on and devise some language around what guidance around what is best practices.
Do we want to set this aside until that's done, Dr. Gant, or are you?
No, I'm okay with it going forward. I don't, like I said, I don't want to open up the floodgates for reporting to be done in cases where it's not, what the policy says, but I'm okay with it moving forward. And, if there are tweaks that need to be made, or if Dr. Thomas and Dr. Watley find that there are implications for the regulations, then I fully trust that, they'll bring it back before or make those changes and let us know or what have you.
Absolutely. I'm making a note of it right now.
And my final 2 cents before Dr. Yeager says, listen, we need to vote, is it's been my experience that whether or not somebody's a mandated reporter, those disproportional reports are going to happen, because if they believe being abused, whether they're required to report it or not, they usually will.
Oh, okay. Okay.
Okay. I guess the only thing I'm going to add, even though it's trivial compared to this very important discussion, is the comma after property. Investigations that occur on school property may not doesn't need a comma. And then I'm okay voting it forward. Won't be into any future changes, but I agree that this is work that the district needs to do to figure out. Okay, so all in favor of moving forward JGI and JGI R1 as revised? Oh, sorry, we need a motion to move it forward.
So moved.
Second.
All in favor?
Aye.
Aye.
Thank you. All right, I think we can do the last three in one swoop.
I
They
really
are,
think we can, Dr. Yeager, because all of these are covered under compulsory attendance law. And so I feel like we need to rescind these, in my opinion. I don't know what anyone else thinks, but
to rescind them all. Okay, so you've changed the recommendation. Okay, so they're covered elsewhere. Is that what you said?
we serve students. Students come to school. I mean, we can't, I don't feel comfortable saying, pointing out that you're a married student, that you're a student or a parent. Like, I just feel like that's highlighting.
Outstanding.
Yeah.
I'm all for that.
And I just think they're students. Once we start getting into their personal situations, I just find that we can lead ourselves to be a little discriminatory. So
Yeah. None of this is what required by law. And I assumed it was just pretty old stuff.
It is.
Hey,
Brilliant.
I move we rescind. Let me blow it up.
JQF, JQG, and JQJ.
So moved.
Dr.
Second.
Gant, any? All in favor of rescinding JQF, JQG, and JQJ?
Aye.
Aye.
Aye. Wahoo, 6:21. Thanks for your hanging in there, especially Lawrence and Angela.
We're a team, Dr. Yeager. We're a team.
I appreciate you very much. All right. Wahoo. Thank you, everyone. Thanks especially for the really thoughtful conversations. Do we have a motion to adjourn?
So moved.
Oh, second.
All in favor?
Aye.
Aye. Good night, everyone.
Good night.
Thanks
you
for putting in the
all.
extra time.
All right.
Bye.
Have a good evening.